Okay, good afternoon, everyone. I'd like to welcome you to the afternoon presentation on employers' top 10 questions about COVID-19 answered. My name is Brad Howard. I'm an attorney with Brown and Fortunato, and I'm here with my colleague, Allison Davis, who's also an attorney at Brown and Fortunato. We are appropriately socially distanced from one another, but in the same room. And it's our intent for the next hour and 15 minutes to work with the Workforce Solutions Panhandle team to answer the top 10 questions that employers are asking about the new law, its effect on their place of business, what they can and can't do, and the like. So first of all, before we dig into the details, Allison and I would both like to express our appreciation of Workforce Solutions Panhandle for sponsoring the program. It's going to be an action-packed, I think, hour and 15 minutes. We intend to cover a lot of content and also to answer a lot of questions from those of you in attendance. Just by the way of background, very briefly, Allison Davis and I'm Brad Howard. We work at Brown and Fortunato here in Amarillo. We advise employers all across the Panhandle, downstate, and then with the firm's large national healthcare practice around the country. So we've been working pretty much day and night for the last month now to address COVID-19 issues. And it's our pleasure to talk to you about that today. Give me 2 seconds here. I'm going to transition over to our PowerPoint presentation with the 10 questions and answers. Do it again.
Yeah.
Okay. Right there. Perfect. All right, sorry to keep you guys all waiting there. To get started here, what I'd like to do, first of all, is I'm going to go backwards here for a second and talk about the legal framework for the law. And here's what the idea is here. The idea is that we're going to address all the key questions that clients call us about all the time, and then to provide some of those answers to you. So I looked at my inbox, and the first email that I got about COVID from an employer was March the 8th. And we know that you've all been dealing with it since then, some before, some afterwards. The thing that I'd like to do here is to talk about first the overall law. That's the Families First Coronavirus Response Act. It's a very long law, contains a number of provisions. It was passed just last month on March the 18th. It's effective April the 1st of this year. And this law is the umbrella for a couple of other acts, including the Emergency Paid Sick Leave Act and the Emergency Family and Medical Leave Expansion Act. And these laws are designed to work together to address all employers with fewer than 500 employees. The next law is the CARES Act, the Coronavirus Aid, Relief, and Economic Security Act, or CARES Act. This was also passed recently on March the 28th. This is the umbrella for a couple of other laws. And in a nutshell, this law is intended to assist small businesses with fewer than 500 employees. This is about stimulus money primarily, and Allison Davis will cover that in some detail when we get to that question and answer. The next law that we're looking at here that is a part of the legal framework is the OSHA Act, passed in 1970. That covers all employers in Texas. We don't have a Texas OSHA Act. What we have instead is the federal OSHA rules, and so that's what we're relying upon in Texas. The OSHA law, which I'll talk about in just a few minutes about why that really matters to you, has a general duty clause that says employers are required to furnish a place of employment that is free from recognized hazards that could harm employees and their coworkers. So under this law, you as an employer have a duty to ensure that COVID-19 positive employees stay away from the workplace and they don't infect their coworkers. So very briefly, what I want to kind of mention here is when you're trying to figure out what all laws apply to you, the answer is all of these apply to you. When you want to know, well, what is the OSHA law? How does that really apply? here's the way, in kind of a common sense way that applies to all of you. You have a place of business with employees. Someone might become exposed to COVID-19 and become sick. You've got an obligation as an employer to protect the employees that work there. And so one thing that we're putting together as employment lawyers for a lot of clients is what I call a protocol. Now, you're not going to see a protocol in the regulations or in the law necessarily, but Allison and I put a number of these together for employers, and I'd advise all of you to put one together for yourselves. A protocol basically tracks OSHA. It indicates what you need to be doing according to OSHA guidance to provide a safe workplace during the COVID-19 pandemic, including minimizing social interaction, social distancing, sending employees home who are sick, and then promoting telework and a number of other provisions. If you go through the OSHA guidance for employers under COVID-19, you can begin to craft your own protocol. And then what you want to do is make it very specific to your particular place of business. The next standard that applies to employers is the general negligence standard. And recently there was an employer that was in the news here locally where some employees had made some allegations, but that's not unique. That's going all across the country. And what you need to be concerned about as an employer is this: am I making the right kinds of decisions that will protect my employees, but also protect my place of business from an allegation that I could have done more? So you've got a duty to your employees to provide a safe workplace and not to be negligent. And so if you know or should have known that one of your employees was exposed to COVID-19 and then you failed to take precautions in the workplace to protect other employees, then you may arguably be negligent to your other employees or their families. So those are the laws that we're talking about. I want to add one more law that there's not a screen for, and then I'm going to give you just a 1 minute, 2 minute variation of how this affects you in the real world. So the last slide that I don't have here, but I wanted to add it to you just verbally, is the Fair Labor Standards Act, the FLSA. So the new laws, the new federal laws, contain requirements, and if you fail to satisfy those requirements, then an employee can make a claim against you at a later date under the FLSA for the pay that you denied them. Not only that, but also liquidated damages, which means that same amount again, as well as attorney's fees. So what Allison and I believe is going to happen is that after COVID-19 has passed, hopefully soon, once that has passed and it's cleanup time, a lot of lawyers will be taking a lot of calls from employees who claim that their employer violated the law, any one of the laws that we just talked about, and they're going to be seeking some damages. So as employment lawyers, how does it work in our world to answer these top 10 questions? And then we're going to get into the questions and answers. Here's how it works. An employer calls me or calls Allison or calls both of us, or they email us and say, I've got all kinds of COVID issues. What we typically ask them to do is outline the situation, tell us whether there are specific employee or family issues there. In a lot of cases, there are return to work issues that the employer wants to find out about. They might have issues about safety of their employees, but also maybe their customers or their clients. They may have an issue about, we have an employee who's been tested, but we haven't got the results yet. What do we do? We have a lot of questions about employee leave issues. What am I required to do under the new laws? How does that work with my current leave that these employees already have? Employers have questions about their options. What do I do about getting this stimulus money? And how does that affect my obligations? Do my employees qualify for this kind of leave, this extended sick leave and family medical leave act? Should I go beyond that to give them other leave? How do I need to reconcile those leave banks? And so in light of those questions that we answer all day and all night lately for employers, we've decided to put together the top 10 questions. And I'll turn it over to my colleague, Allison Davis, to start with question number 1.
By far, the most asked question right now is, what are the reasons that an employee can take paid sick leave? There are 6 reasons an employee can take paid sick leave, and they're detailed out on your screen. But I want to start with the biggest issue. And honestly, I've been getting tons of questions on this, and I know Brad has too. The preface to all of these is an employee must be unable to work or unable to telework for any of these 6 reasons to even come into play. So what does that mean? What that means for me, what that means for somebody else in an office is if you can't work at your office for one of these reasons, but you can fire up your laptop and do your job and do everything you need to do at home, then you're teleworking and there's no reason to take paid sick leave. And an employer is not required to provide paid sick leave for someone who can effectively telework. I also want to mention that somebody who doesn't normally work from home or can't do their regular job from home, but who you can give a different set of assignments to or a different set of duties, it's telework. It qualifies. That person's working. They're working whatever those hours are that they report, and they get paid regular wages for those hours. So assuming that someone cannot work and cannot telework for one of these 6 reasons, then they can take emergency paid sick leave. So the first reason is the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19, and the employer still has work for the employee. So I'm going to punt on that for a second because we're going to detail what a quarantine or isolation order is in detail in a later slide. The second issue is the employee has been advised by a healthcare provider to self-quarantine because of COVID-19 concerns. So I have to tell you, the questions I'm getting on employees wanting or needing to self-quarantine, many of those are related to an employee who wants to self-quarantine or isolate, who's afraid to go out in public. And I just want to say this list of reasons has become just a kind of tattered piece of paper for me because I keep referring back to it. And I would encourage you to do the same because I think it's easy to forget right now that the reason is advised by a healthcare provider. Also, the Department of Labor recently issued regulations on this, and they qualified that advice to self-quarantine has to be based on a healthcare provider's belief that the employee has COVID, may have COVID, or is particularly vulnerable to COVID. So an employee has to be advised by a healthcare provider to self-quarantine because of one of those reasons. So the third reason is the employee is experiencing symptoms of COVID and seeking a medical diagnosis. So the Department of Labor has also put out information on this, saying that this third reason for leave is really intended to be a little bit short term because somebody who's experiencing symptoms and seeking medical diagnosis, I mean, that's not a 10-day thing, right? You start having symptoms and you go seek diagnosis from your healthcare provider and you're going to seek a test. So there's also additional information on symptoms. What we first got out was this list of reasons. Well, the Department of Labor has since identified symptoms that I think we've all been talking about for a while, but it very clearly has to be fever, dry cough, shortness of breath, or something else identified by the CDC. So I do want to take a minute to distinguish. We've just covered the first 3. Well, the first 3 reasons are related to an employee's own illness. And the bottom 3 reasons are something very different. So reason number 4, the employee is caring for an individual subject to an order of quarantine or isolation, which is reason 1, or has been advised by a healthcare provider to self-quarantine, which is reason number 2. But in this case, it's caring for somebody else. And again, we originally got just this plain reason, just that language, and the Department of Labor later came out and qualified who we're talking about that your employee might be caring for. The exact reason says individual, but the Department of Labor later said that individual needs to be somebody like a family member, a roommate, or someone else with whom your employee has a relationship that generates an expectation that your employee would provide care for that person. So this is not your employee is taking a paying gig to pay for someone else who's subject to a quarantine or isolation order. This is more like somebody in their their household or immediate family. So reason number 5, you're going to see this over and over and over again because this is also the reason for expanded FMLA leave. This is if the employee is caring for his or her minor child whose school or place of care has been closed or whose child care provider is unavailable due to COVID-19 precautions. So that is quite the sentence, right? The first issue is it a minor child? In the regulations, the Department of Labor came out and basically acknowledged that FMLA generally talks about one definition of a child, and this said minor child. What the Department of Labor has said now is this also includes a child over the age of 18 who is incapable of self-care. So we're basically talking about a minor or somebody incapable of self-care, and their daycare is closed, their school is closed, their child care provider is not available. The 6th and the last reason is really the most unknown. So this is the employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services. We don't have that specification yet, but it's a possibility that that will come up at a later date. So again, I would advise everyone to have this list handy because this is what you're going to keep going back to when you're looking at whether somebody's entitled to paid sick leave. So as I kind of mentioned earlier, the second most asked question is what qualifies as a quarantine or isolation order? And I've got to say there was quite the debate on this because we went a week or two, I think 2 weeks probably, between when we got the law and when we got some regulations. And lawyers like us are not used to finding our way in the dark. So thank goodness the Department of Labor came in and they gave us some good information on quarantine or isolation order. So it is any quarantine, isolation, containment, shelter in place, or stay at home order issued by a federal, state, or local government authority. So what does that mean? Right now, we're in Amarillo. I'm sure some of you out there are also in Amarillo. Amarillo is under a shelter in place order as of March 30th. So that counts, that qualifies as a quarantine or isolation order. And it actually expands a little bit on the exact language of the statute because we were looking at something that seemed maybe to be a very narrow reason. So shelter in place orders count, stay at home orders count. So pay attention to where your employees are and whether they're under those kinds of orders. So also a quarantine or isolation order includes when a federal, state, or local government authority has advised categories of citizens to shelter in place, to stay at home, isolate, or quarantine. So this really comes up when we have things like, individuals of a certain age are advised not to go out. They're advised to shelter in place. So really, when you're going back to figuring out whether somebody is entitled to paid sick leave and that person is asking for paid sick leave because they've been told that they need to quarantine or isolate or shelter in place, then I would just urge you to go back and I would look at, is it a federal, state, or local requirement that they shelter? And make sure that you're following those. The other issue is I'm getting a lot of questions on whether an employer can tell someone you need to go home and isolate or shelter in place. That's not the case. There's nothing in the 6 reasons that is an employer mandated isolation requirement. So keep that in mind. If you're sending somebody home, you certainly can, but that is not the same as a shelter in place or quarantine or isolation order. And then number 3, are employees entitled to paid sick leave if my business is closed? We've been getting this question a ton because businesses are dealing with, reduced foot traffic, reduced just business in general based on shelter in place orders, and then employees working reduced hours because of that reduced business. So the answer is no. And really, it seems complicated, but if you think about a regular sick leave policy, this will kind of help you around that conundrum. So an employee must be in need of leave because they're sick. So it's not that you don't have work as an employer to give to an employee. That doesn't count at all under one of the 6 reasons. It is if the employer has work for that employee. So if the business is closed because of an economic downturn or a shelter-in-place order, then the Emergency Paid Sick Leave Act does not apply. Okay, and I'm going to hand it over to Brad to do a question for him.
So I can see them. I want to see them so I can make sure. Yeah. Just the top like they were before. I don't see why it's not showing up now. Okay, that's fine. Okay. Sorry about that. I'm going to go ahead and go. Reagan, if you don't mind, I just want on my computer, I can't see everybody from Workforce Solutions. Could you just unmute for a second and tell me that you can hear everything okay?
Yeah, we can hear everything from you guys. You're doing good.
Great, thank you. Thank you. Make sure we're wasting everybody's time putting on a presentation that nobody can hear. So now that I know we're good, I'm on question number 4, and that is, may we, the employer, require the employees to utilize paid leave first? And the answer is no. I'm going to cover that in a little bit of detail, but the general rule is that an employer may not require an employee to use other available leave, paid leave, before using sick leave under the Paid Sick Leave Act, which was just passed. The reason's pretty basic, and that is the Emergency Paid Sick Leave Act is a significant benefit to employees designed to protect them during the COVID-19 pandemic, and an employer can't deny it, period, end of story. Now, at an employee's election, and that's why we bolded that, the employee may choose to utilize paid leave instead of leave under the Employee Paid Sick Leave Act. That is, employees may choose to use their paid leave first if their reason for leave under the Paid Sick Leave Act only entitles them to 2/3 of their regular rate of pay. So I'm not going to do it here, but here's what you do as an employer, and it's really important you figure this out. Initially, when you have an employee making a request for leave, go back to the list that Allison talked about just a few minutes ago. That's your 6 bases for leave under the Paid Sick Leave Act. Go to those and identify which of those applies before you make any decisions, and be sure that you get that part right. Another tip that I would put out there is that the employee may want to use their Sick Leave Act leave first, but then if they're still not able to return to work, they may want to trigger their other leave. And what Allison and I advise employers all day long is when you're dealing with one of your individual employees and their request for leave or their need for leave, whatever the case might be, you need to know what all their leave is. So besides understanding what leave they have under the new laws, understand what they have banked in the way of PTO, sick leave, vacation, or otherwise. Because when you make a decision about whether the employee is entitled to a certain amount of leave, you can first look at this required leave under the sick leave, the new law. But then after that, they may not be able to return to work, but they may have 2 or 3 weeks of PTO or the like. They may have some vacation. They may want to take some unpaid leave for a little bit longer. And so you want to understand what all the leave is before you make any decisions about that. And one thing I'm going to do, I'm going to put a kind of a timeout signal up, like in football or basketball when the coach calls a timeout. As an employer, it's important when you're confronted with the situation. Allison and I are on the phone all day long now and all night long dealing with employers on COVID-19 issues. A lot of times an employer will call somewhat panicked. I've got this situation. I just became aware that one of my employees tested positive or has the symptoms or has been exposed to somebody that has the symptoms, or their husband or wife has COVID-19, any number of scenarios. And the employer says, what in the world do I do? I've got to make a decision right now. It's always safe to say time out to your employees that are involved and say, I need to take time out and assess the situation, So I'm gonna go ahead and send you home for the day. I'm gonna pay you for the whole day that you're gone while we assess your situation, and we're gonna get back to you. Make sure you have their cell phone number or the like, and you get back to them. Call a timeout because you might need an hour or 2 or 3 to make a good decision. Question number 5, what documentation may we require from our employees? And the first one is, according to the DOL regulations, you're required to provide an employee is required to provide documentation prior to taking paid sick leave under either of the two laws. Here's the information. They're required to provide you their name, obviously, the dates for which they're requesting leave. So you as the employer don't need to figure that out. They need to tell you, I want to take leave starting on this date for this amount of time, and here's why. You have to understand what that's going to be. What they say the qualifying reason is for the leave. You want to ask them this, and then you want to get an oral or written statement that the employee is unable to work because of the qualified reason for leave. This is all the documentation that you've got to have before you make a decision. Let me tell you why you want to have this. You want to get this information up front because what you don't want later on is some disconnection between you, the employer, and your employee who's asking for leave. You want to understand all that the entire situation. So take notes, document that conversation, get it in writing from your employee before you make a decision. Secondarily, you need to look at the list that Allison talked about earlier, the qualifying reasons for leave 1 through 6, and determine which reason it is. Because that's very important, and how much time they're entitled to, how much compensation they're entitled to, and what your obligations are as their employer. The second bullet point here says additional documentation requirements also exist depending on the type of leave that is requested. So for an isolation order, for example, you're going to want to have the name of the government entity that issued the isolation order. If the advice is to self-quarantine, you're going to want the name of the healthcare provider that provided that advice. If the question is one of child care, you're going to want to know the name of the son or daughter being cared for, the name of the school, place of care, or the provider that's closed or become unavailable, which is a lot of them now, and a representation that no other suitable person will be caring for them. You want to get all that down from them, from your employee, in writing before you make a decision. And the reason is this, it's kind of like this, for those of you employers who've been unfortunate enough at some point in your career to deal with an EEOC complaint because an employee said, I was discriminated against. What we always do, what employers always do when somebody says, I've been discriminated against, even if it's not an EEOC complaint, even if it's an internal complaint, we always advise employers, sit the employee down, get a written statement, get all their information, commit them to it, date it, sign it, so you know what their story is, so you can investigate it. Same thing is true here. You want to be sure that you've got all this documentation in place. An employer may also request employees to provide additional information as needed to support any tax credits pursuant to the law. Employers are not required to provide leave if materials to support the applicable tax credit have not been provided. And then if you have questions about that, you can look to the IRS website. So one thing I want to mention, just briefly touch upon here that's not on the slide, but kind of an additional tip that Allison touched upon is this. Some employees in this day and age are just scared and they don't want to be at work, but they don't qualify under conditions 1 through 6. So I got a call like that from an employer yesterday. I've got a 70-year-old gentleman who doesn't want to be here, but he doesn't have a qualifying condition 1 through 6. Can we send him home? Can we give him leave? Can we let him use vacation? What are our obligations and what are our options? And the answer to the obligations was, based on these facts, you have no obligations. The second question was, what are our options? Virtually unlimited, provided that you can spare this gentleman, he doesn't need to be at work, then you can trigger his other leave. You can document it as a voluntary request. You can get him to sign off on that. So the whole point here is, we've always told employers for years now, document on write-ups for terminations. Same thing is true here with the paid sick leave and the expanded Family Medical Leave Act. Get all the additional documentation you need to assess the situation and to protect yourself. The next question, number 6, is, and this is really something that we get a lot of calls on. It's really a hot topic now. I understand a number of the employers here on the webinar today have less than 50 employees. So the question is my company excluded from these new laws because we have less than 50? We have 45 employees or 15 employees or 20. The answer is not the whole business. So really it's kind of a maybe. Small businesses that have fewer than 50 employees might be exempt from providing leave under the new laws. They might be exempt, but it's a very narrow exemption. In order for an employer to claim this exemption, first of all, an authorized officer of the business, not just any person in the company can say we're exempt, it needs to be an authorized officer, and they have to determine the following. And before I go through 1, 2, and 3, just kind of briefly, the point I want to make here is if you're going to consider saying we're exempt, let me tell you right now, the whole company is not exempt. Even if you can meet 1 through 3 here, which are difficult to satisfy, but let's just assume that you believe you can meet 1 through 3. It doesn't mean none of your employees are entitled to their leave and to the sick pay under the new law. All it means is that some may not be. And the reason they might not be would be if 1, 2, or 3 is applicable. And basically what it says is that if you provide this, in a nutshell, if you provide this leave to this employee, it's really going to endanger the financial health of your small business. And I'm going to tell you right now, if you make that determination, what's going to happen is you're going to be questioned extensively about it. You're going to be challenged at some point in time by the Department of Labor, perhaps by an employee or a former employee and their lawyer. So here's the advice here is it is an employee by employee exemption, not the entire company, not the entire employer. The next point is that what you're making is a determination under the law. So in order to make that determination, you need to document the facts and circumstances that you believe meet the criteria under 1, 2, or 3 in order to justify that. So what I would say is, what Allison would advise an employer is, before you trigger this exemption, this is one where I think you want to call your employment lawyer because it's complicated and it's risky. If you're wrong, it could be a calamity for you after the fact. So you want to get legal advice on this. But kind of in a nutshell, you want to consult with your lawyer. You also want to consult with your accountant. And a lot of our clients, we have clients of all sizes, but certainly a bunch of small businesses, anywhere from 5 to 25, 30, 35 employees, a lot of family-owned businesses, things like that. With those kinds of businesses, in our experience, you all have an accountant who helps with your taxes and your financial requests. Contact your accountant with these criteria and walk through and see, do you have the documentation to support that? Put that case together, make that determination, make sure that you believe you can prove the case is airtight. If you can do that, then you're going to apply the exemption to a particular employee's request very carefully, explaining there's an exemption here. Here's the reason that you're exempt. Here's why we can't work with you on this particular request. And again, you got to be right about this. The last thing I'd kind of add there as an aside, it's not here on the slide. If you've consulted with your legal counsel and your accountant, you've got the whole case documented, even then my legal advice to an employer would be consider all other options before you trigger this exemption, because it exists for a reason, but it's also a very difficult exemption to trigger and to prove. Next question, and we have a number of healthcare providers here that are online today, and also our firm represents hundreds of healthcare providers, so we deal with these questions all the time in a very general sense. Well, the new law has really carved out an exception that's raised a lot of questions. That is whether a company is excluded because it qualifies as a healthcare provider. In a very general sense, the answer is no, the company itself is not exempted because it provides healthcare services, but individual employees may be excluded. So let me walk through that for just a minute. An employer whose employee is a healthcare provider or emergency responder may exclude such an employee from the new law provision. So it is a provision where you're a hospital, you're a pharmacy, you're any healthcare provider. They're defined in the regulations from the Department of Labor. But you are a company that employs healthcare providers. So before you make the determination whether somebody or some class of employees is going to be exempted from the new laws, you've got to first decide, are they a healthcare provider? Well, the definition's right there. Look them up. It can include nursing homes, home health providers, pharmacies, and the like. It's right there in the regulations. Additionally, yeah, here we go. That's a good list right there of a number of the providers that may qualify. The key here, however, is that you should make a determination of which of these employees are healthcare providers on a case-by-case basis. And then you've got to decide, are we going to exempt these employees? So what does that mean? So one of these employees wants to trigger their leave under the law, and your position as the employer in the healthcare business is, we can't afford to give you the leave because essentially you're a key employee to our operations, you're a healthcare provider, we can't part with you. It's a case-by-case basis. The DOL has said in its recent proclamations that employers must be judicious when using the definition to exempt employees from the provisions of the new law. What that means in a nutshell is to be very careful. Now, which employees within the healthcare provider, company can be excluded? Well, look at that very carefully. It can be virtually anyone employed there as a healthcare provider, but it isn't everyone. So if you're a healthcare provider and you've heard or you've read somewhere online that you're exempt from the new law, then our position is no. As a company, you're not exempt. You fall under the law. Certain of your employees may be exempted because there are good reasons for you to do that, and that's what this exemption is about. But our advice to healthcare companies is to narrowly construe the exemption to ensure that you comply with the new laws. And the next question, I'll turn back over to Allison, question number 8.
So I'll say we haven't had this question come up practically yet because people are still within that first 2 weeks. But what we're hearing a lot from clients is, okay, so they have 10 days of paid sick leave. What do we do when that employee runs out and they can't come back to work? So the answer is, it depends. And the big it depends is whether you're a regular FMLA employer. So what I'll first say is, don't forget the basics. We have a set of new laws that applies to this very specific situation, to COVID-19. But you still have employer policies. Hopefully you have a good handbook. And then all the other laws that normally apply to you still apply. So we have paid sick leave for those 6 reasons I went through earlier. And then we have expanded FMLA leave. So really what we're talking about here is not the expanded FMLA because that is just for childcare. But somebody takes paid sick leave for something that is not a childcare reason and they run out. What do you do? Okay, so if you regularly have to comply with the FMLA, meaning you're an employer with 50 or more employees, don't forget the FMLA applies here too. So the issue becomes, is your employee ill? Is the employee unable to return to work because they're subject to an isolation or quarantine order? Well, that's not going to fall under typical FMLA. But if your employee can't come to work because the employee is ill, the employee has COVID-19, the employee has been admitted to a hospital or is home and still sick following this first 10 days of emergency paid sick leave, then you want to think about application of the FMLA. And Brad and I had a pretty spirited conversation about this exact thing earlier, because the definition of serious health condition under the FMLA, nobody has gotten that far on whether COVID-19 is a, quote, serious health condition. But I've got to say, if you've got somebody who is in the hospital and being, cared for by a healthcare provider, I think it's going to likely qualify. That is a specific case-by-case determination, and you want to call your employment counsel, because if somebody runs out of paid sick leave and they're ill and you think it might be a serious health condition, or you're concerned it might be a serious health condition, you want to have that conversation with counsel and you want to document. The same issues come up when you've got an employee who can't return to work because they're caring for someone else in their immediate family who has a serious health condition. Don't forget the FMLA. FMLA is super tricky. It can be super tricky. Call your employment counsel, have that conversation, but just don't forget that it exists. So FMLA is not expanded, but it's not extended. It is expanded for a new reason, but it's not extended. You've still got 12 work weeks. So that 12 work weeks is it. But as we all know, the rules on how much FMLA you give somebody, that's changed from 12 weeks and it's it to now maybe you have to make an additional extension as a reasonable accommodation to an employee. So consider that. Again, those are very fact-specific determinations, so call your counsel. So non-FMLA considerations. It's completely possible that you've got somebody who doesn't qualify for FMLA because they haven't been there a year, that you don't offer FMLA because you're not a large enough employer. Well, don't forget your handbook. I ask for employers' handbooks all the time because I get a question about somebody who needs leave, and the first thing I want to say is, let me see what your policy says. A lot of employers have policies on unpaid leaves of absence. And don't forget that you have that. They're usually discretionary, but flip back to your handbook, look at what it says, and make sure you're abiding by those policies. I'd also say if you've got somebody who has accrued PTO, vacation, sick leave, let them take it. I think employers are going to be hard pressed to defend a decision that, okay, well, we had an employee out on leave, they used their paid sick leave, they still needed leave, and we didn't let them use their PTO or vacation. If that's banked, I'm encouraging our clients to allow employees to use that. Also consider a furlough. I know furloughs are really hard decisions to make for employers, and nobody loves that. But I will say right now, the TWC is being pretty generous, I think, about how they are awarding unemployment. And so it's possible that you could discuss this with your employee and come to a mutual agreement that they're going to be furloughed for a particular period of time. And in the meantime, that employee can apply for unemployment. So question number 9, I'm actually going to turn over to Workforce Solutions because they are the gurus on the shared work program.
Thank you, Allison. So while we're on the subject of furloughs, the shared work program is a program by the TWC that is an alternative to furloughs. So what shared work offers is flexible work-based systems that can allow your employees to keep working while still supplementing their income with unemployment wages. So in other words, they would work part-time. Their hours need to be reduced by at least 10% up to 40%. And if you could advance the slide, Allison.
Yes.
Thank you. So like I said, it's for partial unemployment benefits. And the workers can choose to participate, but employees who qualify will receive both wages and shared work benefits. So it simply supplements for hours that they would normally be paid for. Allison, if you advance it one more time. Thank you. So in order to participate in shared work, the employer needs to first submit a plan to the Texas Workforce Commission. And my coworker, Angela Workman, and I both work at Workforce Solutions, and we are in the Business Services Department. And we'd be more than happy to help you submit that plan to the TWC. But shared workers must submit their unemployment claims. They must be eligible for regular unemployment benefits. They have to accept work offered by the employer. So if you as the employer would like them to come back for part of their work, they must be available for that. And like this last one says, they must be available for work. So they shouldn't be on vacation or anything. They should be ready when the employer calls them. As I said before, if you'd like more information on that, you can call either myself or Angela Workman at Workforce Solutions, and we'll be happy to help you with that. Thank you. Allison?
Thank you, and I apologize for being a poor assistant in advancing slides. So question number 10. So what are the limitations on my company to take out a loan under the Paycheck Protection Program? So the Paycheck Protection Program is really designed as a small business loan. So it is for businesses with fewer than 500 employees. There is an alternative for size standards for the number of employees established by administration for a particular industry, but a good general rule is that fewer than 500. I will note that, you know, there are some laws that require you to figure out the number of full-time employees you have or the equivalent of full-time employees. This is not one of those laws. You are to count full-time and part-time employees just the same. So there is one exception. So if a business has more than one physical location and they're a food services industry, this 500 employee threshold is per location. So really the limitations that we're talking about here apply in a couple of different ways. So number one, you've got eligibility limitations. So employers can receive loans for covered small business concerns, which are concerns that the applicant has experienced as a result of COVID-19. So all of the laws we've been talking about today are specific to COVID-19. So we've got a couple of reasons here. So a business has experienced a supply chain disruption, staffing challenges, a decrease in gross receipts or customers, or a closure. I've got to say, the work with our clients has really shown that almost everybody is having some sort of decrease in gross receipts or customers or staffing challenges. And so those two in itself are the ones that tend to come up just a ton right now. So the maximum loan amount for most employers this is a very complicated formula here, because of course it's the sum of two different things, and it's the lesser of those. I will tell you the general rule, the easy to remember rule, is it's about 2.5 times the average total monthly payroll cost. And really you figure out that total payroll cost for a look back over the 1-year period. So for employers not in business, as of February 15th, the maximum loan amount is a little bit different. So this Paycheck Protection Program loan has very specific allowable uses. This is the biggest limitation I'll see, and then there's, you know, payback limitations. So the first one is you can use the loan for very specific reasons only. So that's payroll costs. It's continuation of group health insurance benefits. It's employee salaries, commissions, and other compensation. It's payment of interest on a mortgage obligation. And I want to really highlight that because I've gotten questions about whether it includes the principal on mortgage, and it doesn't. It's rent obligations and utility. Utility obligations are defined pretty specifically in the statute itself. It's electricity, gas, water, telephone, internet. This is a very specific list, and it's only to be used for those purposes. I'll say one more big limitation is, while you may be able to get the loan and use the loan for these reasons, there is a limitation on what amount of the loan is forgivable. And basically there's a reduction for if you have reduced employee salaries by more than 25%, your forgiveness is going to be decreased. And also there is kind of a complicated fraction for reduction of your loan. But basically the comparison is how many employees did you have over the life of the loan versus the number of employees that you had at that time of year, the year before, or earlier this year in 2020. So we are still kind of uncovering all of the details of the Paycheck Protection Program loan. My understanding is that the lenders are still getting information on how to administer those loans. So we're encouraging people with questions to contact their employment counsel to discuss their plan of action for whether this is the appropriate way to get relief versus other avenues. But then once you decide this is the way to go, your lender is really kind of your person who probably can answer questions the most. Okay, and then I'm going to turn it back over to Brad to handle a couple of questions.
One thing I'm going to cover here actually before we go with some questions is I wrapped up, I took some notes last night, looking over a bunch of my notes from the last month of what have employers called with, because we want this to be as useful as possible. What have employers called with, and what advice have we given kind of across the board to employers that might be helpful to you as you address these situations in your own workplace. So some of these tips are pretty straightforward, others a little more complicated. First one, very straightforward, be deliberate in your decision making. Like I said earlier, take the time out if you need it, send the employee home for the day with paid leave, err on the side of caution, and then make a decision. Always buy yourself the day if you need it. You don't have to make a decision split second that you may regret later on. Next one, the situation we've seen frequently is, and the advice is going to be to push back gently and document it if you have an employee who's being unreasonable. I'm going to give you an example. An employer we do work for, who's all over the state of Texas, had an employee who complained, this is an unsafe workplace because I have to punch in the keypad as a security measure to get into the door. And the problem wasn't so much that the employee complained about, that's a safety issue and certainly valid. The employee yelled at the employee supervisor the complaint in front of a lot of people, very insubordinate, if you will. Well, pre-COVID-19, most employers would do at least a write-up, possibly a termination of that employee. I counseled the employer, this is COVID-19 era, I think I'd handle it much more gently. So we worked with them to do a write-up of the employee because she was wrong about a number of things. There was a safety protocol there to punch in the keypad so that you wouldn't have to put your finger on the keypad. The employees had all been advised about this protocol. She just failed to follow it. So that was in the documentation. Also, the employee was counseled that we're all careful about our safety, and it's understandable you'd raise your concerns, but you need to be more gentle and professional in the way you do it. And then we didn't put that as a write-up in the employee's file as formal documentation. We just addressed it. So the key thing there is address your problems with your employees, but maybe be a little bit more gentle because they're very concerned about their own safety right now. People are walking around very anxious, and you've all seen that, I'm sure, in your places. Next tip, document all your decision making now with a date and a timestamp on it, because that'll show the good faith basis for the decisions that you're making. And if you're wrong and that's questioned later on, at least you've documented the good faith reason that you felt that was in compliance with the law, and that'll go a long ways to defend yourself later if you find yourself in that position. I mentioned the protocol earlier. If you want to draft your own protocol, go online, type in OSHA and employer protocols, policies, COVID-19. You're going to get to a big document released by OSHA, talks about COVID-19. There are a lot of general safety precautions there. You're going to want to incorporate those carefully into your own protocol. You're going to want to tailor those to your own place of business. Add the other things. If you're a construction company, you're a healthcare provider, you're a grocery store, or anything else, you're very different, but you want to put together your protocol. And the idea is that you train your employees on the protocol. And what it says is, this is how we handle a COVID-19 situation that arises at our place of business. Every employer should have a protocol. In fact, an employer told me recently theirs was a lifesaver because it gave him the information he needed to make a decision under stress, because he could put that together ahead of time. To Allison's point, review your policies and procedures on leave, especially before you make any decisions. Next tip, avoid terminations that are COVID related, if at all possible. You don't want to hang your hat on that right now unless you are certain that you're right. To Allison's point, call your employment counsel, get advice on that. Next thing is, another tip is, you might want to be a little bit more lenient than normal with regard to attendance and enforcement of some of your policies, because it's a pandemic. Your employees are on edge, you're on edge, we're all on edge. We're all concerned about our safety and our families and our coworkers and everybody that we love. So you may need to be a little bit more lenient because people are on edge, and consider going a little bit easier on some of your policies because it's a pandemic. So you might say, okay, if I provide this kind of leave to this employee today, is that going to be held against me in a year? Well, probably not, because it's a pandemic. So I think you can document pandemic is the reason we extended the leave that this employee didn't have, because we want to be compassionate. So consider that and definitely document it. But there are exceptions to that rule. Employers are calling and saying, I've had employees test positive for marijuana. Can I terminate them in this day and age? Yeah, if that violates your policies, your drug policy, then yes, there's not some exception during COVID-19 for something like that. Next couple of tips. If you're a football fan at all, you want to think long-term. If it's a football game, like a college football game, and you're in the first quarter and you're in your own territory and it's 4th and 2, you punt the ball. You punt the ball because what you want to do is you want to play to win the game in the 4th quarter. With your employees, think about it this way. We're trying to get our heads around this as well as employment attorneys, and that is the COVID pandemic is going to pass. Most employers are going to want the employees that they have or had at the workforce. They're going to want to pick things back up. So you've got to make good decisions and understand that there may be some exceptions to the rule. And as long as you document pandemic as the reason for that, that's going to work fine. The very last thing is assume that all the fact decisions that you're going to make about whether an employee qualifies for the emergency sick leave, the expanded family medical leave, whether you're entitled to reduce your workforce because you're taking stimulus money. Can you do that? All those decisions need to be analyzed carefully now because they're going to be scrutinized later when the pandemic is over. And those are our kind of final tips. Now, a number of you have sent in questions now, and then some of you just a little bit earlier. So what Allison and I'd like to do here for the next, see what time it is here, it's almost 4:30, the next 15 minutes, I guess, is we're going to try to answer as many questions as we can to provide a little bit more information. So one of the questions came in and said that 100% of our desk employees are set up to work from home. Many of those employees are juggling homeschooling their children and their work duties. And I can certainly sympathize with a lot of employees around the country right now. Some are doing it successfully, others not quite so well. Are we able to use the sick leave and the expanded family medical leave on an intermittent basis if those employees need a day here and there to focus on their children, but they otherwise work from home? It's a great question. So the first thing is, if you're going to use intermittent leave or allow an employee to use intermittent leave, you need to come to an agreement with that employee about that. But it really depends what the grounds are. So if the employee falls under grounds 1, 2, or 3 of the list we talked about earlier, and the employee has their own health condition that they and you are concerned about, well, that employee can't be coming back to your workplace on an intermittent basis and possibly exposing others. So no, they can't come back on intermittent leave to work unless they're working remotely from their homes, for example. So you've got to use a lot of caution there if it's reasons 1 through 3, and make sure those employees are only working remotely, not at your place of business, if you're going to allow them intermittent leave. But if you're looking at reasons 4, 5, and 6 primarily to involve others, and you want to work with your employee and allow them some intermittent leave, that's fine. Also, I might add there that Allison and I have advised a lot of employers to consider more flex scheduling. So your employee is working an 8-hour day from home. You might not need her or him necessarily from 8:30 to 5:30. It may be that you can expand their workday to 7:30 p.m. because they need more time during the day to take care of their kids. You can work that out with your employees. So that's certainly something that you ought to be doing. I think the next question, Allison, is yours.
Yes. So we received a question asking whether it's an appropriate use of emergency paid sick leave for employees who are sent home by their employer after someone else in the workplace tested positive. So the short answer is no. So we went through kind of in ad nauseum detail those 6 reasons that an employee can take paid sick leave. And one of the holes we're finding is if you send somebody home because you're concerned that that employee has been exposed, but there's no symptoms and they're not seeking diagnosis, they're not at home because they're subject to a a quarantine or isolation order that is issued by some branch of the government, then the paid sick leave provisions really don't cover that question. So what I would say is, if you send someone home and you're concerned they've been exposed, encourage that employee to seek medical diagnosis, because if the employee has been advised by a healthcare practitioner to self-isolate, then they are in fact eligible for emergency paid sick leave.
Lots of good questions here. We'll try to cover as many as we can in the next few minutes. So another employer question, I've been working on new policies regarding the FMLA leave expansion and the emergency paid sick leave policy and others. How detailed do these new policies need to be in light of current events? Can I refer our employees to the government site with a brief description of each of the new laws, or do I need to do more? Since these are government-driven requirements, do I need the board to vote on them? So it's a very good question, and a lot of employers have called us with those kinds of questions. Let me tell you this, our viewpoint would be, first of all, with regard to referring your employees to the internet to say, these are the new laws and these are your rights, I'd be more specific. So I'd be more specific in the sense that you want to refer them to a very specific site if you're going to go that route, and refer them within that site to the exact reason. So that might be, for example, under the Paid Sick Leave Act, reasons 1 through 6 there that are the key. You've got to make that really accessible to your employees. Don't just say, look online and see what the new laws are, and if you want to invoke your rights, your leave, let us know that. I think it wouldn't be a bad idea, if you can have the time and the resources to do it, to memorialize those new laws as they affect your leave in a short form document for your employees, but if not, at least refer them to something very specific online. With regard to whether you need board action, again, that kind of depends on what you normally do. Because these laws are mandatory for most employers, 500 or less employees, because these are mandatory, then it's really important that that you follow them. Whether your board of directors thinks it's a good idea or not, the law requires that you do that. So I don't feel like you would necessarily need board approval, but if you feel better having board approval, that's fine. They should approve very specific laws that your employees can easily access and understand. The last point I'll make there is that if you don't make it easy for your employees to access their new rights, and you effectively deny them those rights, that's going to be on you later on when the DOL decides to take a look at that. The next question here, I believe, is going to be yours, Philip, and that is, if we have to lay off employees, how will it affect us later? Will our unemployment compensation rise?
Sure, thanks, Brad. So that question depends on a couple of issues. First, if the business shuts down to a closure order from a governmental entity like the state of Texas, or like here in Amarillo with Mayor West, or if it's for medical reasons, you as the employer can request that a waiver to the chargeback from the TWC. You would just have to submit whatever kind of proclamation was given from a governmental entity. Otherwise, if it's just for a cautionary warning because something could happen, then no, generally they'll deny the chargeback protection.
Great, thank you, Philip. And the team there at Workforce Solutions is pretty amazing to address a lot of these issues, especially those related to unemployment comp. So thank you for that. The next question we've got is, what do we do about our employees that travel out of town for their work? Some of them a couple times a week, others less often. Should we suspend that travel? How should we handle that? What we're advising employers is that if you have, in certain lines of business, have a whole lot of people that travel, or certain people that have to travel all the time. So our advice there would be only travel for essential purposes only. If it's discretionary, typically would advise against that. So it should be essential travel only. And then for essential employees to travel only. Even then, our recommendation is against putting them on an airplane. Even though I travel for work, Allison travels for work, we fly all over the place. Under normal circumstances, that's not the case now. Certainly your employees stand a greater risk of exposure in airports and on airplanes in the course of that travel. So we're recommending against airline travel unless it's absolutely essential. Other travel in cars and the like, make sure your employees understand the protocols, the need to maintain distancing when they're on the road, and to follow your policies and procedures. The next couple of questions we have, I think, will be yours, Allison.
The next question we got is, what is your obligation to employees who have no symptoms but are simply afraid to come to work for fear of contracting the virus? So I'll say, first of all, that the Emergency Paid Sick Leave Act does not address this question at all. This does not qualify as a reason for paid sick leave, but your obligation is the same as it would be to your employees always. Look at your policies, look at what you have in terms of paid leave. I would say if you have paid leave, this employee has paid leave in the bank of any type, I'm encouraging our clients to permit their employees to take that paid leave. If they can do without that employee, if you've got a key employee issue, call your employment counsel, because that's a little bit more difficult to deal with. But somebody that you can spare in the workplace, I'm encouraging clients to allow that person to take that kind of paid leave. The follow-up to that is, do we have to pay them during this absence? Well, it depends. So if you're going to allow somebody to take accrued PTO or vacation, yes, you'd follow your policy on that. If you are permitting somebody to take an unpaid leave of absence, well, that's very different. The third follow-up is, are we obligated to hold someone's position until they return? Strictly speaking, no. But look at your policies, look at what you've done in the past, and try to be flexible, because kind of the first biggest concern is what Brad mentioned earlier. So we're all dealing with this pandemic, but we all are going to come out of it, and we're going to all need to work probably at the same rate we were working before. At least that's our hope, is that everything's going to come back. May take a bit, but you're going to want your workforce. So think about whether you want to hold that position for them, because if you do, maybe allow somebody to take an unpaid leave of absence. Perhaps you could negotiate an unpaid leave of absence and return on a position available basis. If you've got a key employee and you have work for them to do and it's critical for your business and they just are not coming into work, call your employment counsel, because you may need to make a different decision, but you want to document. So can employers who have made accommodations for their employees to work remotely debit the FMLA extended leave or the paid sick leave? So the answer to that is no. And really it goes back to both of the new acts, the paid sick leave and the expanded FMLA Act, only apply when an employee is unable to work or telework. So if you've got somebody who's working remotely, perhaps they're working remotely reduced hours, but they're still working. And so you're not paying out paid sick leave. It's not that they're unable to work. Mm-hmm. Got one more question. So if we've been approved for the Paycheck Protection Program loan, what percentage of that needs to be used on payroll, rent, etc.? What time window do we have for this money to be spent? So I'll tell you, I have read the Paycheck Protection Program Act, and I saw nowhere in there that there's a specific percentage that recipients are required to use for specific types of expenses. That being said, I would get your accountant involved and I would speak with your lender. I will tell you that you can only use those proceeds for those specific permitted uses, but I have not seen a breakdown of percentage. Again, lenders may know more about that than we do because they're getting the direct information on how to process those loans. But get your accountant on board, work with your lender, and then the time period, the window is, it's 8 weeks from when you get the loan. So the act is available for a very specified period of time. It's to June 30th of this year, but the covered loan period is 8 weeks from when you get the loan. Okay, so I'm gonna turn it over to Brad for just a couple more.
Actually, Philip, if you're still on the line, if you can hear this, the question just came through about a seasonal employer. Can you see that one by chance? If not, I'll just ask you.
I sure can. I'm sorry about that.
You're fine.
But I'm going to turn this over to Angela.
So, okay, there I am. Sorry. Okay. So for seasonal workers, let me pull up my notes here. Let's see. Okay, if you have seasonal workers, temporary and seasonal workers are only eligible for the unemployment for the weeks that they would have been employed if the disaster had not occurred. So they are covered under the Disaster Unemployment Act. So it would only cover the time that they should have been employed with you in the first place. So say if they were scheduled to work for 4 weeks for you before the disaster happened, then under normal circumstances, then they would be eligible for 4 weeks of the unemployment payments at this time.
Excellent. Thank you. Thank you, Angela. So I'm going to end here on a question, and I think it's the most common question that's come in today from employers, and that is, I'll just read one version of it, but I've seen a bunch of them. If my employee or employee's child tests for COVID-19, do they need to provide proof of the test, whether positive or negative, for the Paid Sick Leave Act? So far, I don't see that the government is requesting proof, but I'd like proof that my employee isn't just taking a paid vacation at home. So here's what you want to do. What you want to do is to go back to the slide on Emergency Paid Sick Leave Act, and there are 6 options there. You want to figure out which one applies to your particular situation. So some employers call and they say, you know, I've got an employee who is scared to be at work and they want the sick leave. Can they have that? And so I looked down 1 through 6 and none of those qualify. But then to Allison's point earlier, I might still tell my employee, you don't qualify for the paid sick leave, but we're willing to let you take some of your PTO, if assuming that you can spare them, or assuming that they could work remotely, you might put them into remote work. But you want to address on a case-by-case basis 1 through 6. But let's say that the employee has been sent home or is required to stay home because of reasons 1 through 3. So there's some concern there about the employee's health. The most common question that I'm getting is, what do I have to let that employee come back to work? Because that employee says, I'm fine. And my wife says, I'm fine and I should go back to work. Can I come back to work? And what we're telling employers is, while that isn't addressed specifically by the law, go back to the earlier slide at the very beginning of the presentation, and that is your duty to provide a safe workplace, and the idea that you as an employer might be negligent if you breach your duty to all the employees there. So what's going to help you ensure that you discharge your duties by allowing an employee to come back to the workplace when they were sent home or away because of COVID-19 concerns? And the answer is something from a healthcare provider that's satisfactory to you as an employer. What I'd like to see is a release to return to work. So if they don't have a negative test result, and we understand some of the test results are backed up by days or even weeks, depending what the test is and who's interpreting it, then you don't have a negative result. So the concern is, so much time has passed, can I let this employee come back to work? We advise employers get a note, have the employee get a note from a healthcare provider that says they are eligible to return to work. That protects you as an employer and allows you to discharge your duties. If they say, my doctor won't give me a note, then it's a pandemic. Maybe, and then doctors are overworked at this point in time. An email may suffice from the appropriate healthcare provider. An email may suffice from a nurse practitioner or physician's assistant at the doctor's office. a phone call between the employer and that particular medical provider, provided your employees consented, that may suffice, provided that you document it. But our advice is you need something in your file from a healthcare provider that says it's okay for this employee to come back to work, because you don't want to be playing doctor if 1 through 3 were the reasons the employee was sent home to begin with. So our time is up, as I understand it from Workforce Solutions Panhandle. We're going to go ahead and cut this off at 45 after. It's been a real, first of all, in closing, it's been a real privilege to be here today. Allison Davis, and I'm Brad Howard. We've really enjoyed the opportunity to try to answer the most common questions that employers are asking. We know we can't answer them all, but we tried to answer the most common. We hope the advice has been helpful. Also, Workforce Solutions Panhandle is a great resource for all of you and all of your questions. And during these trying times, which we hope end very soon, we wish you safety, health, and all the best. I'll turn it back over to the team at Workforce Solutions Panhandle. Thank you.
We just want to say thank you to everyone for tuning in, and we will make this available on our website at WS Panhandle by tomorrow. You'll also get, for all those who registered online, you'll get an email with some helpful links, as well as some social media ideas for those of you who need to still reach out to some of your customers over social media. But as always, if there's anything you need from Workforce Solutions, let us know. Thank you very much.